What's up, everybody? Welcome back for another recap of the Darrell Brooks trial. And there was a lot of the same today, but some of the stuff we're going to highlight and talk about is how in the same witness, Mr. Brooks can ask some really good questions and then remind us all that he's a pro se litigant. And he stepped in it multiple times, and how he handled some of the victims and some of the witnesses to the carnage that was the Waukesha Christmas Day parade, where multiple were dead, 50 plus injured. And I really, really think that today sunk him if he wasn't already sunk before. So let me know in the comments if you think he was already sunk, or which witness today do you think I'm going to save to the end as the witness who sunk Darrell Brooks. He was going that way as it is, but now it feels like it is more confirmed. So welcome in. My name is Peter Tragos. If you're new here to the channel, a lot of you commented on the last video that you joined our channel and subscribed to this channel because of the Darrell Brooks trial. I am a plaintiff's personal injury lawyer in the Tampa Bay area, also practiced in criminal defense. My dad does a lot of criminal defense. We are trial lawyers. Tried a couple cases this year. We have another couple trials coming up before the year ends. So this is what we do. We're in the courtroom all the time. We're handling, oh yeah, people are saying fix my echo, probably because I don't have my AirPods in. Let's put this in here. All right, trying to fix this here. I forgot to put in the AirPods, so we'll get to that. But so that's what we do, and we break down and talk about these cases on the internet to help people understand the judicial system, to help people understand the civil and criminal justice system, and understand how it works in our country. And that's for people that live in our country and around the world. Hopefully the sound is better now that we have the AirPods in. Some people are saying no echo. All right. Well, regardless, we've got the AirPods in. Everybody's here. Let's get to trial day 4. It started with the argument over jurisdiction. Again, the cases we talked about yesterday don't mean anything. They are not a real argument that has any legitimacy. There's some people in the comments that have asked a lot of questions about sovereign citizens. We've discussed it at length. He's going to continue to argue subject matter jurisdiction, and the judge is going to keep saying it's been debunked. We're moving on. I don't think we need to spend any more time on it personally on this channel, because there were some more interesting things that happened today with some of these similarities throughout the trial, where he just says grounds after every objection. The judge explained to him today what grounds actually means. Grounds means give me a reason for the objection. Legal reasoning, legal grounds. The judge explained that means that the question is either vague or it's speculation. So stop just saying it every time. It didn't help because he kept saying it every time, but at least she was answering that question. Additionally, one of the videos I made earlier this weekend, because so many questions came out about why he keeps asking questions about the plaintiff and who the plaintiff is, and if you know the plaintiff, and if the plaintiff is an entity, and if they're filing charges, and all those questions about the plaintiff that really don't make any sense, and we explained in detail how we got there. The judge told him that the plaintiff stuff ain't happening today. And if you ask, she's going to cease the cross-examination and move on to the next witness. And that happened during one witness, and she said, I'm going to give you one more chance, but stop asking questions about who the plaintiff is in these cases. Stop confusing the witnesses. That is not a legitimate argument to make before the jury. And we, of course, heard from a lot of these witnesses. Some heard horns. Some saw driving all over the place. Some saw a more targeted line of driving. Others didn't see anything at all. Didn't hear anything at all until it was too late and the car was plowing through. We had people testify about injured children, bodies flying, head injuries, traveling to the hospital and to the ER, because of the injuries from this accident and this incident. After the morning break, more theatrics from Mr. Brooks, even though he doesn't necessarily consent to being called that. I've had a lot of people send me in my messages different things that happened, like because it's in all caps, he doesn't consent, or he only talks about having a different name, or he just doesn't, he has a rap name or something that he wants to go by. So the mysterious question of how he doesn't consent to be called by his own name continues. You're right. This was not an accident. I have car accident on the brain. Thank you for reminding me. Jennifer McCauley asked, Peter stopping his cross-examination would have been cause for mistrial, correct? No, not if she warned him over and over again and he's just abusing the process. She can cut off his cross-examination. But she's going to try not to. And there are some other things she did today that I think were amiss by the judge. And we're going to talk about some of the mistakes I think the judge and the prosecution both made today, as an indication that it is so hard. It is so hard to stay in form when you're dealing with a pro se litigant. And we'll talk about some of that later. The baseball director, when he was on the stand, we were talking about after the morning break, Brooks comes back, theatrics, crying, wiping his tears, apologizing over and over again for getting emotional, apologizing to the jury, apologizing to the court, apologizing to the witness, grabbing his Bible, pulling something out of the Bible, showing the jury that it's a Bible. And, it shows you that a lot of this is calculated, unfortunately. But when the baseball director was up there, I believe it was the baseball director, and he was asking about all the people that were injured around him and why he didn't render aid to those people, and starts blaming the victim for just worrying about his children who had been hit by Mr. Brooks in the car, and how you were only worried about your kids. You were only worried about getting those kids out of there. Not a good look. Not a good look at all to blame the victims in a situation like this, especially when you're the defendant that caused it. Not even the single layer of separation as a defense lawyer that they bring to these situations. And then he's been talking about how a lot of these witnesses have made claims. And aren't you a plaintiff in the case? And we know about this from some other cases as to whether or not they've filed a lawsuit. And a civil lawsuit can absolutely be something that's admissible if you have a financial interest in the case. But he's talking about victims' assistance funds that maybe help with some medical bills. And again, you step in it. Sometimes it can make sense. Like, hey, there's a claim being made, so they have a financial interest in the case. Okay, that can go to somebody's credibility. And the judge allowed him to ask those questions, as she should. I think he actually won a lot of objections today where the state objected and the judge overruled those objections. So that's good. That's been happening. I've seen some comments saying the judge is going overboard, helping him and coddling him. Absolutely not. But I can understand why you may feel that way if you've never seen a pro se litigant try a case. So I totally understand that. He mentioned about how these witnesses have seen the videos before. They've talked to the state attorneys before. They've passed the videos around prior to testifying. Like there's this whole big conspiracy theory out to get him. But one of the very, very interesting witnesses was the forensic video expert detective. And to me, what do you guys think? Do you think he did a good job or a bad job cross-examining the video forensic detective who guesstimated his speed based on the video? Because in my opinion, I think he did a pretty good job. When you have an expert, they're obviously going to know more about what they do than you did. People saying, good job, meh, bad job. I think he did a decent job, horrible job, good job. So to me, you only have certain things you can pick apart, right? Let's just think as a criminal defense lawyer at this point. You can pick apart his expertise. You can pick apart his method. You can pick apart the outcome, how he got there, if he's biased, whatever. And Brooks picked out that he's biased. He works for the state. He's paid for the state. Fine. But he did a really good job of talking about his inexperience and how he really hasn't worked with this at all in a live situation, and how he wasn't even certified when he started his preparations on this case. Those are arguments we've made in DUI trials sometimes when we have these cops who aren't DRE certified testify to the HGN test. And some people saying confusing. Oh, I agree he doesn't understand basic human emotions, but I thought he did a pretty good job with that forensic cop because he dug in. I don't know how he knew that. I wonder if if this guy was deposed maybe by his lawyers and then he read their deposition. But to me, I thought he did a pretty good job. I thought he did a pretty good job explaining how the inexperience could result in inaccuracies and how this entire program was not just new to this detective, but was new to this police force, potentially was new to trials. And to me, I thought he did a pretty good job. And I think one way we can tell that he did a good job is the state attorney, the male state attorney, who I've given a lot of compliments to throughout this trial, because I think he's done a great job. He was a little miffed when he came back on redirect. And what did he do? What do lawyers always do? On redirect, if they're a little miffed and they feel like they can overpower the other side, because again, he is a pro se litigant. Well, he came back and fired away a bunch of direct questions. You did this. You were certified. You have used this before. Other police stations use this. They use it all the time in trials. This is not a novel technique. Other people, it's not just criminal cases, right? They do it in civil cases. Defendants use it. Insurance companies use it. Accident reconstructions used it. He went after him hard. He got some great points across. They were hard-hitting questions with perfect answers. The answers were actually in the question, but there's a problem. They were all leading questions. They were questions that the state attorney's office knew or should have known are totally improper. You can't see what you get away with at trial as a lawyer. You have to do what's right. You have to follow the rules of criminal procedure. You have to follow the rules of evidence. So the issue is that going to be one of the issues for appeal? That at multiple times throughout this trial, the state has begun asking leading questions, getting the points across the way they want to. But if that was a criminal defense lawyer on the other side, all those questions would have been objected to. So did Brooks object? The answer is yes, he did object. But did he say hearsay a couple times? Of course, because that's his go-to objection. The judge again says, dude, can you read the hearsay rules so you can try to understand what the definition is? Because these are not hearsay questions. However, there were, and I listened very closely because I thought this was happening. There were a few times because he was firing, that state attorney was firing questions, firing direct questions. Brooks objected a few times, did not give grounds. He did not give grounds a few times, and the judge immediately overruled his objection. So I don't know if she blacked out or didn't know or just assumed he said hearsay, which is understanding. I agree with you. Common sense is dead. He objects improperly, but if you just say objection with no legal grounds, the judge should ask for legal grounds unless the judge is just going to consider all legal grounds. And in that case, she should have sustained his objection because it's an improper question. It's a leading question. So to me, that was a bit of a miss. We got some more information after one of the breaks that the state feels like they are a bit behind. And a lot of you were asking. Some people said, I think this is going to go really quick. Some people said it's going to go really long. I said usually with pro se defendants, it's annoyingly long. The one trial that I had, okay, the one experience I'm bringing into this, because not a lot of people have experience trying cases against sovereign citizens or pro se litigants, but the trial we had that lasted 2 days should have been a half a day. So it took 4 times as long as it should have taken, maybe a full day with jury deliberation. So a half a day to a full day, it took 2 full days. So my bet is it's always going to take longer. The state let us know today they are a bit behind. They're doing some scheduling things, but they even mentioned to the judge, we're behind because we did not know how long these cross-examinations were going to be. But at this point, they should know because he asks almost the same questions to everybody. So he did a good job, in my opinion, against the forensic expert. But where did he blow it? Well, he blew it when he asked a bunch of the injured victims, well, your injuries weren't that bad, right? Why'd you wait a day to get treatment? Well, the injury to your foot wasn't that bad, right? You didn't go to the urgent care right away, right? Because when you ask questions like that, first off, you never want to minimize injuries that victims had because you ran over their foot with your car. Number one. Number two, you ask these questions, and these are the kind of answers you get. Well, there was blood everywhere and people laying on the ground, and there were more immediate and life-threatening injuries to tons of people in the street. That's why I decided to wait to go to the urgent care the next day for my sprained foot or broken toe or whatever it was. Damning answer. Damning answer. And again, the state on redirect, asking questions they know are not admissible. He even objected to some, and this time some got sustained, but the state knows that certain questions are not admissible and are not proper. So they just need to be careful with that. All right, before we get to the witness that I believe sunk him, let's answer some questions here. Doug D is a new member. Welcome, Dougie D. Bets on how big the live crew gets tonight. Melanie guessing 1.3K. We're about at 1,100 now, so let's see if we can break that 1.3K mark. Azam was in here early. Congrats on 139K subs. Any giveaways? Nope. Next giveaway will probably be at 150K subs if we can get there before the end of the year. If not, we'll do something at another number. I'm having school stuff with my students, so I'll be joining the rewatch crew. Thanks for recapping. Stace on the case. I cannot imagine being a victim and having the perp question me. It's a rough thing to watch, that's for sure. Cassandra, the judge told the prosecutor to ask a witness a question about the empty boxes on the exhibit. Is this normal? Okay, so I missed the exact thing the judge said, but I heard Brooks and the judge kind of discussing it afterwards. I think the judge was asking for either some background or just telling the state they had to ask a couple questions before it would be entered in. It didn't seem like anything improper to me. I was working, it was on in the background, so I didn't back it up and actually listen to that closely. It is not abnormal at all for the judge to tell a lawyer, you got to ask some background questions or ask about this or make sure you lay this foundation or whatever when entering an exhibit in. That's not abnormal. I don't see that being an issue at all. Bev, the jurisdiction / plaintiff / grounds argument might be cute in traffic court, but asking about who the plaintiff is when 6 people were murdered and 60 plus people were injured is downright ghoulish. Bev, thank you for saying this. And thank you to everybody that's in the chat and commenting and adding to this conversation, because we can't forget while we're watching this and I'm analyzing it as a lawyer, somebody who's been a prosecutor, somebody who's been a criminal defense lawyer in cases like this. We analyze it like this. We discuss it. We discuss the legal angles and ramifications and rules. But the jury is a bunch of normal people like you all who's probably sitting there thinking exactly what Bev is thinking. And that's why I like to get your input and your comments and your questions here, because that gives us a little peek into what the jury think. And you've been spot on. Not everybody's exactly right, and not everybody's called the outcome of every case, but you've been spot on more times than you haven't. in the Depp case, the Rittenhouse case, the Ahmaud Arbery case, the George Floyd case, and a lot of these cases. So I appreciate the input. John O'Rourke, what's going to happen with his opening statement? My guy, Pan the man. Pan man. He can give his opening statement when the state closes their case in chief. Before he opens his case in chief, he can give his opening statement at that point. I don't know if he will or not. It kind of seemed like he's not sure. He definitely seems like he wasn't prepared for it at the beginning of the case. So we'll see. If I was him, I would definitely give an opening statement and a closing argument, and I probably wouldn't take the stand. That's probably the best route for him to go based on how this case has gone, but we'll see. Andy Sturkowitz, if Brooks decides to testify, can he then plead the fifth when the prosecution cross-examines him? Great question. Eddie Mayer also asked, how will he handle his own testimony? Who asks the question? So Andy, there's literal case law on this. We've discussed it. There are rules on it. There's a whole book of cases and statutes and precedent on this exact question because this is something criminal defendants want to do and would try to do. But the answer is no, you cannot do that. If you waive your Fifth Amendment right to testify, it is waived for cross-examination, and the state has the right to cross-examine you, and they will cross-examine you. And to answer the other question, the way it would work in a pro se case is Darrell Brooks would take the stand. He would give a narrative, just explain what happened, what he was doing that day, why all this happened, how it was an accident. He didn't mean to hit anybody. Somebody else was driving the car, whatever his story is. He takes a stand and says that. Nobody asks him questions, but the state can object if he starts testifying to hearsay or things that are inadmissible. The state can object. After he's done giving his narrative, the state gets up, they cross-examine him, and then he has an opportunity at the end to give another narrative as redirect because he is his own lawyer in this case. Ann Niles is a new member. Welcome, Ann. Thanks for joining the crew. Connie, with his head down and the jury was leaving, he sighed heavily. He knows he is sunk. Well, we're going to talk about more about him talking under his breath when we get to this last witness. Terry W., there isn't even a question that he did this. It's hard to give him credit for anything because of what he did. That's fine. If you want to take that stance, that's fine. We still believe in our country. People have the opportunity to defend themselves. They have the opportunity for a defense. They have an opportunity to make the state prove their case and a trial by jury, which is happening here. And I think justice is going to prevail in this case. And I think we all know what the outcome of this case is going to be. And it's a reality of understanding our judicial system, which is kind of what this channel does. So I understand how you feel strongly about him. I feel it too. And I understand, especially with some of the witnesses today. So I do understand where you're coming from. Mo, honestly, at this point, I feel the state has proved that there are injured, deaths, etc. We found out today at one point the speed was 33 miles an hour. All we need now is the diagnosis of his tox report and case closed. I mean, do we even really need that? One of the witnesses said they estimated his speed at 55 miles an hour, which is pretty crazy. Ooh, we broke 1,300 people in the chat. We're at 1,400 people. Someone just notified me. That's fun. Let's keep riding that. Hit that subscribe button if you're here from the Brooks case and you haven't already. Law and Lumber. I've been getting a lot of questions if somebody is, advising Brooks on the side and giving them some tips. Maybe it's Rob. Rob, you giving him some tips on how to represent himself? Anyone that listened through that debacle, regardless of the background, deserves some support. That hurt me physically to watch. Brutal. And we haven't even gotten to what I felt like was the most damning testimony of the entire day. John O'Rourke, did you leave because cop yelled shots fire or because of the parade tragedy? 100% agree, Pan. There was a lot of misses in his delivery, we'll say. Thank you, Jay Gross, for the super sticker. Brooke said, the high point for me was when he, under his breath, muttered, makes sense when he asked how the coach measured out yards. Yeah, some of it just sounds like normal conversation, which is always interesting to me when something like that happens. Lois Ann, I see your question. I answered it in depth yesterday. The difference between pro per and pro se, there really isn't one. There was a whole hour in this on one of the hearings, and the judge is like, listen, legally speaking, it means the same thing. You represent yourself. This is something sovereign citizens try to do. And they can make some arguments that sound convincing in some of these hearings when in reality, it's just not how it works. It's just not how it works in our judicial system. All right. So to me, anybody have a guess? I'll give you a second to guess in the comments which witness I think sunk him the most, we'll just say, and was the most damning so far in the trial. You can either reference her by name or by her position. It's a female, I'm giving that away. And in the meantime, hit that like button if you haven't already. Subscribe to our page. Do all the things, comment, etc. As I'm getting your guesses in here. The hot dancer, somebody said. The girl with the long hair, the first dance teacher, Alyssa. Donnie Ewing said there's no constitutional right to mow down innocent people, children, and grandmothers. Nobody said there was. Nobody, absolutely nobody said there was. So yes, I think you are all referencing the dance coach or instructor with, I think, Extreme Dance Team. It was game over after this. This was brutal to watch. Anybody with a heart and a brain, after listening to her, I think was saying, let's just get this trial over with, because I think we're really getting to the crux of what this carnage looked like and what he did and how cold it feels. And at one point, again, Brooks was muttering things under his breath, so much so that the state attorney had to ask the judge to tell Brooks to stop making comments under his breath because the witness is very emotional and doesn't need this. But something interesting happened. When they were playing the video, which was obviously brutal, we didn't get to see it. At least the stream I was saying didn't show it, thank God. But when we watch the video and the judge tells the jury to disregard the comments, that to me, again, seemed like a problem. And if he had a real lawyer representing him who looked through this video, I would think they would have redacted out those comments. Because could you imagine, just based on my chat right here, what the comments were in the video of the car running through what that dance coach witnessed? To me, that was a miss by the state, by the judge. That should have been redacted, knowing he doesn't have a lawyer representing himself. He has a little more argument about subject matter jurisdiction, but when he crossed the dance coach or the dance teacher, whatever they're called, and he said, you said in your statement there were people lying on the ground at the hospital, right? And she was like, yeah. He's like, why were there people laying around at the hospital? She's like, because there were so many people that were seriously injured and needing emergency medical care that they had to lay on the floor and stand up and sit in chairs because there were not enough beds available. That's what you call stepping in it. It's like, what are you doing? It's brutal. And he's so cold, he just continues and asks the next question. And then what does he say? He says, so were the doctors and the nurses not doing their job? And she was like, no, they were doing their job, sir. There were just so many people injured that there weren't enough nurses and hospital personnel to deal with it. And he was like, oh, so you don't think they were helping fast enough? She's like, no, there were just so many people that were seriously injured. And she explained how she held some of these kids and held their hand and rode with them in a squad car to the hospital. I mean, her testimony to me, incredibly believable, incredibly heart-wrenching. She had no, he couldn't even try to get, financial interest in the case or bias or credibility issues. None of that with her. Literally none of that with her. And yeah, somebody's saying, I liked when some of the witnesses just looked at him and said it how it was. Yeah, the girl that got her foot run over where her kid also got hit, and he was trying to act like no big deal, big deal. You got your foot run over, so you weren't that seriously injured. Oh, and he said that to the dance coach as well. So if they didn't need immediate medical care, they obviously weren't that seriously injured. She's like, no, they do have serious medical issues. There just were literally not enough beds and doctors. Muskoka Mama. Do the witnesses know that the defendant will be questioning them? So they probably didn't know it initially when this case was starting. Once the trial started, the state attorney probably tells them and lets them know that, in fact, the criminal defendant is going to be the one asking you the question so that they can be prepared for that. They don't know what he's going to ask. The state attorney's office can't tell them what he's asking other witnesses or prepare them for things like that. So that's why some of them seems like they don't know the answer to the plaintiff questions and things like that. Bev, would love to have a lawyer in lumber and law simultaneous viewing of the trial. You know what? Me and Rob, when we get together, it's usually a little higher spirits. We need to do a stream, me and Rob together, of Live versus PGA. Do a little more lighthearted stuff like that. I think we need to make that happen for a happy stream, a happy law stream. Mo, the most damning testimony was the dance instructor and the lady who was hit with her kid. If you had stood 18 inches north, would you have waited for treatment? Dang. Absolutely. Absolutely. Matt Blake, if Brooks is convicted, will he be allowed to hire an attorney for the penalty phase of the proceedings? Yes. He can hire someone for sentencing phase. He can hire someone for appeals and things like that. Yes. Debbie Faison Cook. Peter, why do people represent themselves? That's not really smart, is it? The old saying goes, somebody who represents himself has a fool for a client, meaning it's foolish to represent yourself. Brad P. Just in general, do the antics Brooks has been using ever work? I don't know how the judge and state have the patience they've shown thus far. I agree. I don't know how they have this patience, but you just have to, and it comes with the territory. But I will say, I have never seen them work to this level of where he's going, where he is. I mean, just think this. Is there anybody out there listening to this that thinks that him saying, I do not consent to be called by my name, and saying that this state has no subject matter jurisdiction over me over and over again in front of the jury, would anybody think that has a positive connotation or makes you think, oh, yeah, this makes sense. This guy knows what he's talking about? Because he's not only representing himself, he's not only making these cold arguments, talking to people he either injured or they witnessed the carnage that he caused to their friends and family members. He has to deal with all that with representing yourself, but he also has the weird antics with the sovereign citizen stuff on top of it all. Jay Goss, what support is provided for the mental health of the witnesses and jurors for participating in this trial? So good question. I'm not sure if the jurors are provided anything, but the witnesses, law enforcement, they are usually provided mental health counseling, especially law enforcement if they witness things like this. And that can be part of the victim access fund that they've been talking about, can pay for some mental health counseling for these witnesses. I had somebody, I don't think it was you, Jay Goss, somebody asked me this on Instagram a few times and I forgot to answer in the last stream. So I'm glad you asked me and thank you. Yes, a lot of this is provided to the witnesses in cases like this. Cindy Lou Who, Peter, if it's proven that he is getting advice from counsel on the side, could the attorney be reprimanded given the judge's ruling on side counsel? Yes. I should say in Florida, let me just talk in Florida. If you do advise a pro se criminal defendant or really give legal advice to somebody representing themselves or that you don't represent in a case, and they're making representations that you're giving them, you're putting your law license on the line, you could be reprimanded. There could be some negative actions taken towards you from the bar, from judges, depending on what the circumstances are. 1.8K watching, only 68 likes. That can't be right. 68? It's got to be more than that. Maybe DM is just trying to get the people liking. I like it. I like your style. Tori, diverting wrong doing to other agencies / people seems to be what he is trying to do. He has zero emotions. I think he's doing a bunch of different things. And I'm not sure any of them are working. But it's not for lack of trying. He's trying to poke holes. He's trying to make it seem like nobody actually witnessed him driving. He's trying to make it seem like there may have been somebody else in the car. To me, I think he's kind of all over the place. All right. Yeah, L. Dot. The judge isn't liking him or isn't helping him because she likes him. She wants to get to the finish line. That is correct. That is correct. Doug D. I don't know how they found a jury for this case with everyone knowing about this case. You'd be surprised. This case was not even the most high profile case we've had this year that they've had to find a jury for. Somehow they always do it. But sometimes it can be very difficult. Peter, your name was brought up in the live feed. Be ready for new members. Tina Odell said, what live feed do you mean? I don't know what you mean by the live feed. I don't think he's getting advice from outside counsel. What I think may be happening is there may have been some depositions taken. I don't know what the rules are. Here in Florida, you can take depos in felony cases. You can't in misdemeanor cases. But if he's reading the depositions, he can read the questions that his lawyers ask these witnesses in deposition. So maybe he's getting some of the questions or line of questioning from that, and maybe he's taking it and applying it to other witnesses and things like that. Galactic Historian, very good points on this show. Thank you, Galactic Historian. Welcome. Join the subscriber crew here. Yeah. Okay. MNP. I heard that this morning. He keeps saying he is appearing as a third-party intervener. Do you think he will raise having multiple personality disorder as a defense? No. He actually did plead insanity at first, and then walked it back and didn't end up pleading insanity. How would you defend him? What would your approach be? I'd probably try to work out a deal. Impish Artist, thanks for the super sticker. Mark Lane, like you in Law Talk, retired and watching all. He just targets Claim Center. No one knows about it in Missouri, Amanda said. This was national news. I remember this was brutal when it happened. I mean, just brutal. And of course, the media went with it and had a lot of things to say about it quickly, but Jenna, your insight is the best. I feel like I'm in a pre-law class. Thank you, Jenna. Although they don't really talk about this stuff as much in pre-law class. This is kind of like a trial advocacy class, I feel like, or evidence or something like that. We talk way more about the law and evidence and how trials work and questioning witnesses and leading jury rules. But I get your point, and thank you. That's a big compliment. We're over 2,000. I feel like it's been a while since we've had 2,000 people. Yes, and Bridget, that's what I think the low-key underestimated thing about the Lawyer You Know channel is the chat and the comments make this so much fun and so much better. And everybody's cool and nice and chill. And we can talk about tough subjects, but still try to, have a happy disposition about it because we're learning, we're understanding, we're hoping justice is coming. We're big fans of justice on this channel. What odds would you give an appeal at this point? 6%, which is higher than a normal appeal. With pro se defendants, they're usually, they can maybe find something. The local channel had a live feed. I'll get you the channel name. The local channel said something about me? What? That would be wild. Yeah. Tell me more. Every jail has a jailbird type lawyer. Sure. He's using summary reports. Yes, those summary reports were taken, and the law enforcement produces those, but those wouldn't necessarily have questions from a lawyer on them. So I'm trying to figure out if he has something, or maybe his lawyers gave him some cross-examination questions or things like that. I'm not really sure. That was me, Lisa McKay said. Peter, can you see? So Crafty Andy. Peter, can you see this case used in a law school class? No. Honestly, this stuff has been tried before. And that's why the judge is just summarily denying a bunch of things. I'm writing down Jill Gianni. Is that who you're talking about? Odell, we'll see. He can appeal it pro se as well, but that's much more difficult. Exactly who is suing him? I don't know if there's been any lawsuits filed against him. From my perspective, he's talking about the claims that are made from the Victim Access Fund, which is, they have a victim compensation fund here where if victims are injured, they have medical bills, they can apply for it. It usually is pennies and they don't ever actually cover everything they need. Melissa Lee, I don't believe it's a death penalty state. He is facing life. Has he ever confessed? I just scrolled past that. I don't believe so, but usually when you talk about an insanity plea, that means you admit to doing the crime, but you're not guilty because of insanity, not because you didn't do it. So that's interesting. Evidence and procedure. Algorithm is new here. That's awesome. Welcome. Rich Cat's learning. Objection, hearsay. Yeah, it's an awesome community in here. Really is. Yeah, stays on the case. Tons of people want to be sovereign when it comes to taxes. Yeah. Was released on $1,000 bail for running someone over shortly before this. I believe it was his ex-girlfriend, and I believe that and that was the prior bad acts that they weren't going to allow in because the judge said it was only one person, and that was too differentiated from driving a car through a parade of people. John, would you like to be part of the prosecution on this case? Not really. I think they're going to win, and I think, they're going to get justice, but it's not really fun to go against a pro se defendant like this. It's taxing, to say the least. Can Brooks charge himself for his legal representation and then take himself to court when he doesn't pay? I don't know if he would have jurisdiction over himself, or what. That would be interesting to see which court he would decide to go in. What was his confusion with the subpoenas? He didn't know whether or not to fill out, whether they need to bring documents in or not. He didn't know how to fill out necessarily all of the different blanks and spots in a subpoena. It could be difficult for a pro se defendant to fill out any paperwork through the court. Okay, perfect. Taylor Flock. Just an FYI, in Wisconsin, the Wisconsin Lawyers Assistance Program does help provide mental health support for jurors in cases like this if they have no other assistance. That's awesome. That's awesome. Azam for the super sticker. You're a champ and you're back. And you're not just with the rewatch crew, you're also with the 2 Live crew here. PHOP444, can he still ask for a lawyer at any time? The judge has said no at this point. No lawyers on the case. Law and Lumber, you have to react or address the end of the day. Judge lays a record for competence. It's such a slick and assertive move from the bench. I've had some issues with the judge, but she went ham today. Gavel dropped, appeal toast. Well, the appeal on that reason, I definitely don't think he's got a leg to stand on for competence issues. He is making sense. He is going through those prior statements. He's impeaching credibility. He is talking about how they have a financial interest in the case. He's talking about how they have inconsistencies in their statement. He's talking about how serious are these injuries based on the statutes that he's charged with. He's picking this stuff apart. He's making objections. He's asking for grounds when the state objects. I actually think he should be winning more of these objections, and the judge is sustaining the state's objections a little too quickly and overruling his a little too quickly. There are no competency issues, in my opinion. I think you're spot on with that one, Rob. Doug D, if you look up his arrest record and how many times he's been in court with lawyers, you think he would be better at objections. Ouch. Shots fired by Dougie D. What will be his best witness? I have no idea. His witness list doesn't seem to be people that are on his side looking to help him. His witness list seems to be random people that he has tried to gather that have knowledge about the parade or what happened. Maybe he's going to call him and say, you didn't see who was driving the car. You heard the honking, whatever it may be. But I have no idea what his best witness is going to be. I really have literally no idea. Melissa Beard is a new member. That's awesome. The out-of-town witness, yeah, but she isn't coming, it seems like. She's in Texas, and she helped put the parade together. I don't know how she's going to help him or be a good witness for him. Yeah, 13 witnesses is what he's on his witness list / the subpoenas he's filled out. It was a wild day, and it looks like it's going to go longer than anticipated. I think the state was planning on being done Thursday or Friday. That might bleed into Friday or Monday. So to me, who's on his witness list? Well, we know there's somebody else that's Spanish-only speaking part of the church that's in a line of people that the state is also planning on calling. Rob is just like hype man to the max tonight. You're the best, Rob. If you guys haven't checked out Rob, Law and Lumber, go do so. Because he's here for the people, man. He's here for the people. He provides great content, and I'm told he does woodworking. I cannot confirm or deny it myself because I've never received a wooden object carved out specifically for me. I haven't received one yet, so I can't confirm or deny it whether or not he actually does woodwork, but I can confirm he is in fact a lawyer. But yes, the case continues on. It continues to be wild. I expect we're going to hear a lot of the same stuff like this, and a lot of the same questions. I think we're going to see a lot of the same. We're going to see the judge and the state get kind of annoyed as they continue through the process. We'll see if it gets shut down any quicker. I mean, they're picking up on certain things, right? So they picked up on the grounds. They've picked up on the hearsay objections over and over again. They've picked up on the plaintiff questions. We'll see if the judge cuts him off on anything else because he's made his point to the jury. Move on. Don't ask these weird questions that don't have any relevance or don't make any sense. I expect that to kind of continue on as we follow this trial. If you guys know anybody that's interested in this trial and wants to check out recaps or reactions like this, share our channel with them. Hit that like button on your way out. That's really all we've got tonight. We always try to answer as many questions as possible. We answered a ton tonight. We'll be back at it tonight and as many nights during this trial as I can to come on, react, and break down and recap as much of this trial as I can. Get your input. It's really important to me to get your input. I want to hear what you all have to say about it. Shout out to Rob for being here after his 3-hour stream with Natalie, Syntax 2600. Yes, that's awesome. Rob is a YouTube master, man. He's got the He's got the stamina on YouTube. He's texting me on the side too, calling me out for saying, "Hey, I can't confirm or deny he does some woodworking. I've heard stories, I've heard rumors. Okay, I've heard rumors he does some woodworking. All right, you guys are the best. I appreciate everyone who joined me tonight. Tell your friends if they're interested in this Brooks trial. Hit that subscribe button if you haven't already. Peace.